John Bash, Sarah Clark, and of course, Heather LeBlanc on behalf of Mr. Baldwin again.
All right, thank you. All right, so we'll start with the defendant's expedited motion for court order excluding defense witnesses. Go ahead.
We have just one technical issue, which is Mr. Bash has not been allowed into the hearing. If he could be allowed in. Thank you. I see Mr. Bash has joined. Ms. LeBlanc will be handling that motion on behalf of the defense.
Thank you, Your Honor. And I will be arguing this first motion. So I know that the court has obviously reviewed the motions of the parties. I do want to very briefly, though, put into the record right now for the court the timeline again with respect to various filings that have taken place with respect to this motion, because I do think they are important for the court's consideration. The first is that there was a deadline for witness list disclosure that was issued by the court, and that deadline was May 6th. On May 6th, both the state and the defense filed witness lists that added new witnesses. The state added 8 witnesses, and the defense added 9, and this was on the same day. Now, later this same day, the state inexplicably files a motion basically claiming that the defense has untimely disclosed these 9 witnesses and that we have been engaging in sandbagging by adding these 9 additional witnesses, again, keeping in mind that they had just added 8 of their own on the same day. Now, the defense does not reciprocate. We don't file any motions claiming that they've been sandbagging or that they've done anything improper, because both parties have in fact complied with the court's order and filed their motions by May 6th. Now on May 21st, we respond and we point out the absurdity of the state's position and of their request. On May 31st, which is a Friday, the state files a reply. And in their reply, they are still calling for exclusion of our 9 witnesses who we listed on the deadline of May 6th. Now, at 6:52 p.m. on May 31st, that Friday, the state also files a notice of completion of briefing, which is basically informing the court that the matter is ready to be heard. There's no withdrawal of the motion. They are still maintaining their position and their request that our 9 witnesses should be excluded, the ones that we filed on May 9th. Now, at this point, the defense is aware that we have 8 days that were scheduled for trial. And with 8 days scheduled for trial, the state at this point has listed nearly 50 witnesses, and the defense had 26 that were listed on our list as well. Now, we know that there's no way that we could get through 76 witnesses in 8 days. It's not possible. And so trial is fast approaching, and so the defense recognizes we need to start preparing for trial. We need to start putting these resources where they need to go and be working toward trial rather than investigation. We have to switch gears. So acting in good faith and knowing the state's position with these motions that we've now filed and briefed over the course of the past month, the defense reviews the case and then makes a strategic decision that we can cut down our witness list significantly. And we proceed to file on Sunday, which was June 2nd, a written notice that we are withdrawing nearly half of our witness list. And so we consent to an exclusion of 5 of the 9 witnesses that the state has requested be excluded through their motion. And so we send a courtesy copy to the state of our notice of our intent to withdraw those witnesses. And we also send a new witness list to the state. Less than 3 hours after we sent those copies to the state, after the state now has this insight into defense strategy, and while the state had just hours before still been standing on their motion that our witnesses should be excluded, the state turns around and less than 3 hours later files an amended witness list, adding witnesses that they still have a pending motion to exclude. That motion is still pending, and yet they file an amended witness list adding witnesses that they are still seeking to exclude per their motion. The next morning then, the state files a notice that they are withdrawing their motion. All of a sudden, there's no prejudice. All is well. all of these things that the state had declared to the court that they would suffer as prejudice by the defense's disclosure of these witnesses on May 6th is now no more. And in fact, they want to go ahead and add some of the witnesses to their own witness list. So we find ourselves, Your Honor, in the absurd position where the state has sought exclusion of witnesses by motion. And this is not through discussion. This wasn't correspondence through emails, through phone conversations where the state says, we think you should pull these witnesses. This is through motion practice. They have represented their position to the court, and they've represented their position to the defense. And they've notified the court, this matter is now ready to be heard because it is completely briefed. And yet within mere hours of getting a look at the defense strategy, the state tries to walk back their motion. Now, obviously, there are rules of criminal procedure that are in place. There are criminal procedure rules that govern time for filing, that govern various procedures throughout this process. And these rules presume that the parties will operate in good faith. They assume, in particular, that the prosecutors will follow their ethical duty, which is to seek justice rather than to simply secure a conviction at all costs. But however, there are times when rules are not sufficient, where perhaps the party is manipulating the court system. And in those times, the court has to look to other doctrines in order to ensure the integrity of the judicial system. And so we look for evidence of manipulation in the court system. And we can do that by looking at the first filing that the state had, where they moved to exclude the witnesses in this case. And in their motion to exclude, again, which was filed on May 6th, the same day that both parties filed their additional witness lists, the state lists out in details the prejudice that they will suffer. They say, even though we filed by the deadline, they point out to the court, there's only 8 weeks. We're only 8 weeks away from trial. The defense, by adding these additional witnesses, they don't have time to investigate this case. And so the defense is engaging in improper tactic, and we're sandbagging the state. The state is prejudiced. These are their words. These are their terms. They also note in their motion and make really what are patently false statements. And what they say is that the state has, at this point, by May 6th, has made all of its witnesses available to the defense for pretrial interviews. That is false. That is not correct. In fact, we had the state's expert witnesses, multiple expert witnesses were actually scheduled to be interviewed after May 6th and were subsequently interviewed into late May. And then even more recently into June based on some new disclosures that have been had. And so that we had not interviewed all of the state's witnesses despite the representation in the state's motion. In addition, the state also told the court and asserted that pursuant to Rule 5501, the state not only disclosed its witnesses, but also has provided the defense with all witness statements and experts' reports, as well as underlying data and a summary of proposed expert opinions. That is also false, Your Honor, because, and the court will see through different motions that are going to be presented before the court, some of which will come before the court today, and others which we will be submitting to the court later. In fact, that is not true. We had not received numerous expert witness supplemental reports. Those had been withheld from us, including one that was particularly exculpatory by Lucian Haig. That had not been provided to the defense as of the May 6th filing of this motion. There were also statements by the state's other expert, Brian Carpenter, that had not been provided to the defense. And to this date, we have, as of this day, we have made numerous requests of the state that they provide these statements that have been redacted through an IPRA request that we had done to try to get a hold of different statements from various witnesses and things like that, communications with the state. And so we are in possession of some emails, for example, email correspondence that does indicate that there are opinions of the state's witness, Brian Carpenter, and yet those have been provided to us in a redacted format through IPRA. So we do not have the ability to see the contents of these statements, but we can see that they exist. Now, there are many, many of these documents, and we don't know fully what might be contained within these various email communications and correspondences between the state and their expert witness. And we've asked the state, in compliance with their affirmative duty to provide statements of their witnesses and statements of their experts and opinions of their experts to the defense, we've asked them to provide unredacted copies. And the response has been, you have to go ahead and identify for us which ones it is you need unredacted, and then we'll take a look at it. That's not how this rule works, Your Honor. The rule works that the state has a duty. They have a duty to go and look for and to exercise reasonable diligence to uncover statements and opinions of witnesses and expert witnesses, and they have an affirmative duty to provide those to the defense. And yet they're putting that burden again on the defense. We have also had disclosed to us over 150,000 pages of other documents. We had, as late as May 23rd, audio recordings that were taken by the state's investigator, Connor Rice, of various witnesses whom the state had listed on its witness list that we had never been provided. And we only received them on May 23rd. And the list goes on, Your Honor. It includes then the state has now filed, as the court is aware, is pursuing use immunity for Hannah Gutierrez-Reed. And in accordance with that, they have now provided over 361 recordings for our review based on statements that were made by Ms. Gutierrez-Reed. Now, the list goes on. There's more. There's more that has been disclosed and that continues to come. But these statements that the state has made in their motion as officers of the court are not true. These are factually not true. And so we are prejudiced. And this is why the doctrine of judicial estoppel would come into play, because this court needs to protect the integrity of the judicial process and prevent manipulation of the court system. And so when the court looks at judicial estoppel, it's a three-pronged test. The first two of which are part of the main test, if you will, and the third, while not necessary, is actually a part of the test that indicates that judicial estoppel is even more appropriate if that third prong is met. And so I'll go through those with the court now. The first is that the party against whom the doctrine is to be used must have successfully assumed a position during the course of litigation. The second is that the first position must be necessarily inconsistent with the position the party later takes in the proceedings. And then finally, while not an absolute requirement, judicial estoppel will be especially applicable when the party's change of position prejudices a party who had acquiesced in the former position. And so we'll start with the first prong. With respect to the first prong, Your Honor, the state has successfully assumed a position. The state took a position in a motion that witnesses should be excluded, and the defense, after full briefing of the case and in reliance on that position, the defense then conceded the state's the relief that the state had sought as to 5 of the 9 witnesses that the state was looking to have excluded. So the state was successful. In its motion, the state tries to indicate that that in fact, a party must have already had the matter adjudicated by the court in order for there to be a successful position that was taken by the court. I'm going to go to the state's motion. And so what the state says is that this must have already been adjudicated by the court in some way through some order by the court. There have been no arguments, is what the state says. The state says the record in this case is crystal clear. There were never any hearings or other judicial proceedings in which the state's initial motion to exclude certain defenses was adjudicated by the court. And therefore, their position is that that means that there was no, that we don't meet the first prong. However, that's incorrect, Your Honor. And if the court will look at the case that we cited, and it's Kuchan, which is a 2024 case, the site is 2024 NMCA 032. And when we look at this case in paragraph 14, the court notes that the respondent in that case did not successfully argue and therefore assume this position in a motion or at hearing. So the use of the word "or" clearly demonstrates that a party can assume a position either by its argument through a motion or also by its argument at a hearing. So it's either or. It doesn't have to be at a hearing. It can also take a position through argument in a motion. And this is further solidified through paragraph 16 of the same case. In paragraph 16, the court continues and states that the respondent could not be considered to have successfully assumed a position about the nature of the West Track until filing the motion for partial summary judgment. It doesn't say until argument of the motion. It says that upon filing of the motion for partial summary judgment, that is the moment at which the respondent could be considered to have successfully assumed a position. And that is what the state did in this case. They assumed a position in the motion that they filed, both the primary motion and then also their responsive briefing. They assumed a position. And they successfully assumed that position because the relief that they sought was granted effectively by the defense consent to that relief. The second prong, Your Honor, has, and I will actually point out the cases that the state cited for this principle. So that was the one that the defense cited. The state cited 3 cases in support of their proposal that a motion has to be argued before the court and there has to be an order in order for there to be a successful assumption of a position. They cite O'Brien, they cite the Gabriel Vigil case, and then they cite a 2014 unpublished opinion, which is non-precedential. So I'll go over the 2 cases that are actually published case law. For O'Brien, in this case, this is a case where the court did apply judicial estoppel. And there did happen to be an order that was entered by the court. It was a pretrial order, but merely finding a case where estoppel was applied and where the court had entered an order does not indicate that the first prong can only be met where the court has entered an order, and that is not the holding of the case. It just so happened to be that in that case, there was an order that had been entered by the court, and therefore that met that part of the prong in the either or. So either in a motion or at a hearing. And so in this case, there was a hearing that was appropriate, but that does not say anything about the fact that one can also take a position through a motion. The Gabriel Vigil case, this one doesn't even deal with judicial estoppel. It actually involved the doctrine of collateral estoppel, which is a different doctrine. So collateral estoppel has a different test than judicial estoppel. And the purpose of collateral estoppel is to promote judicial efficiency and consistency. And the goal is basically to keep parties from relitigating issues from a previous suit. With judicial estoppel, we're talking about a purpose that has to do with protecting the integrity of the judicial process by preventing the parties from, and this is quotes from the various cases, from playing fast and loose with the court and ensuring that the party does not manipulate the judicial system. So in light of the fact that there is a 2024 case, which is the case that the defense cited, that precisely states that a party can assume a position pursuant to the first prong through motion alone, the question again is whether or not they were successful, and we submit to the court that they were. Now moving on to the second prong. The second prong says that the first position is necessarily inconsistent with the position that they take later. Clearly that is the case. Clearly that has been met. The state was first saying that there was prejudice by the inclusion of these additional witnesses on the defense witness list. The state's position was that those witnesses should be excluded. And now they have taken the exact opposite position, saying these witnesses should be able to be called by the state and there is no prejudice by their inclusion. Now, even though only the 2 prongs are actually required, the third prong again indicates that if the party's change of position prejudices the party who had acquiesced in the former position, then judicial estoppel will be especially applicable. And that is the case here. So The defense relied on the state's motion, which the state had told the court on May 31st in their notice of completion of briefing was fully briefed and was ready to be heard. And in recognition of that fact, and recognizing that we are scheduled for trial for 8 days in an attempt to pare down our witness list substantially, we removed, again, almost half of the witnesses from our witness list, revealing significant defense strategy. And we also informed our witnesses. There were some witnesses who were scheduled to be interviewed the following day and then a couple of days later. We informed those witnesses that they were released from their subpoenas, and we did in fact release them from their subpoenas, and we told them that those interviews would be canceled. We sent, again, courtesy copies of our notice to the state along with our amended witness list, and then that's when, within less than 3 hours after seeing defense strategy, the state changed its position. Now, the state proposes that really they can just cure any prejudice to the defense by extending deadlines. But that doesn't cure our prejudice for a variety of reasons. Primarily, because you cannot cure the fact that we have already revealed defense strategy in reliance on the state's position, and the state has now walked that back. We cannot cure that. In addition, we're in a time crunch at this point, Your Honor, and we do not have further time available. The state, in their motion on May 6th, noted that they were prejudiced by the fact that there was only 8 weeks prior to trial. We are now in the position where we only have 2 prior to trial. We did not receive significant information from the state previously, and the reason that that is relevant here in particular is because time is a finite resource. The recordings alone that were disclosed related to Hannah Gutierrez-Reed are so significant and substantial that if we take an average of the time that it would take to listen to each of the calls, and we dedicated one whole person doing nothing else, taking no breaks for a full 8-hour day, it would take that person approximately 15 business days to listen to the recordings. But we don't have 15 business days, we have 10. And not only that, we also then have to look at the potential of having to interview Ms. Gutierrez-Reed. So time at this point, Your Honor, is a finite resource, and the state is playing games to exploit that resource and to take time away from the defense where we should be spending our time in trial preparation. Instead, we are having to deal with the state's constantly changing positions, with their changing disclosures, with the new things that they're adding, and it's fundamentally unfair. And as the state notes in the state's own words, calculated sandbagging is not appropriate. And what they say in their own motion is that they say this kind of manipulation of the courts should not be permitted, and we agree. And so we are asking the court to therefore exclude the witnesses and to grant the defense motion.
I have a couple of questions before I hear from the state. First, you talked about that you decided that you were going to limit your witness list, cut it down because you had to switch gears for trial preparation. The time for investigation was superseded by preparation. If I'm misstating that, tell me right now.
No, Your Honor, that's correct. That is a big part of the consideration as well, which is why we were assessing our case in that moment to determine what needed to be done.
And so you said that you made this strategic decision, and that, but I'm not clear, and that they know what your strategic decision is. Is it anything more than you eliminated a witness?
No, Your Honor, we did not include any additional dialogue with the court or information in the pleadings, but again, we had pared down our witness list to almost half of what it was. And so I think that gives the state a pretty good idea of what we're going to be doing with the case.
Okay. And so then you're talking about this sort of bait and switch is what you're saying, where on May 6th, they had a problem with your witnesses, and then on June 2nd, you took certain ones off, and then on June 2nd, they added 3 of the witnesses that you took off. And I'm not quite sure how that short time frame I know you're arguing a little more than short time frame, but that's quite a short time frame, right?
A short time frame for what? I'm sorry, Your Honor, if the court would
for
clarify.
for them to have added the 3 witnesses that you deleted.
Correct. Yes, it was a quick turnaround. Right. That is correct. Within hours.
And how do you explain that they have always added at the end any witnesses called by the defense, and that you had these individuals on?
That's correct, Your Honor. And so it's a different position, I think, than we would be in if, let's say, the state had not filed a motion to exclude. That's the part that changes, I think, the analysis in this case, because at any point, of course, one party or another can remove witnesses from their witness list. We could not add any more witnesses based on the court's order, but we could remove witnesses from our lists. And there was the catch-all of, any witnesses who were listed by the defense or by the state, and that is correct. However, what's different about this particular situation than the typical instance in which a party may just decide to go ahead and remove witnesses is that we did so in advance of the final trial witness list, for example, that this court has, which I believe is Monday. And so we did so in advance of that in order to say, okay, we're not even going to finish doing these other witnesses. We know where our case is going to go. We're pulling these people off, and this is what we're going to do. And we did that in reliance on the briefing that was filed by the state. And so it's a bit of a different position because the state had already effectively indicated to the defense as well that they did not intend to call those witnesses by moving to exclude them. You can't move to exclude witnesses from trial for the defense, but then be keeping them for the state. That's not what they were saying in their motion. So what they were saying was these witnesses should not be called at trial. And so they're saying that they also will not call those witnesses. We then in reliance said, okay, fine, we agree to not call those witnesses. And so this is a different position than one party unilaterally just removing witnesses from their witness list because it was done in reliance on the state's briefing and on their motions.
So the prejudice is what?
So the prejudice...
You went into this whole thing that is not in your, it's more of your Brady violation motion. So what's the prejudice?
So the prejudice at this point, Your Honor, is we already had canceled and released witnesses from subpoenas. So they were no longer valid subpoenas since we had already informed the witnesses that they no longer had to be there. The witnesses, even though some of them had already been interviewed, the problem is, and again, we don't want to go through an analysis of what each of the witnesses would be because we're not going to reveal further strategy to the state than we already have. And so we're not going to do an analysis piece by piece, to tell them what the import is or is not of each of the witnesses. But suffice it to say that we did an analysis of these cases as a group, as a whole, could be released and could be removed from our witness list together. If only some of them are now coming back, then that can again impact whether or not there need to be other witnesses who would still remain on the list whom we have not interviewed. And the state says, we can just extend the deadline, right? We can extend the deadline to take care of that issue. That's the state's proposal. But again, we have a finite amount of time and we are in full trial prep mode at this point. And so that's the prejudice, Your Honor.
That you can't interview 3 more witnesses because you might have to interview some additional ones.
And that's the thing is we made a decision and a call based on whether or not we might need additional witnesses. That's correct beyond that. But at this point, we don't have the ability to do that. And so that's the prejudice.
So the prejudice is that you're preparing for trial and you can't do these pretrial interviews. You need to articulate it for me.
Of course, absolutely, Your Honor. So that is certainly a part of the prejudice. And so it's multifaceted. So that is a part of the prejudice. The other part of the prejudice that is specifically related to the witnesses is in releasing or removing nearly half of our witness list. We also, again, some of these witnesses are interconnected. And so now we have removed 11 witnesses, and the state is now adding back piecemeal, which witnesses they want to put on. And it happens to be some of the ones that they had moved to exclude. Those are the ones who they've listed as being added. And so the prejudice is that it does impact our case and our presentation.
And then your judicial estoppel is talking about fast and loose, but you're also that, they took one position and then they took another position, but you're talking about all in the same, I don't know, what is it? 48-hour period? They added them and then did their withdrawal, and you're talking about that constituting judicial estoppel?
Yes, Your Honor, because it wasn't just that one moment either. It was the fact that this had been briefed over the course of a month as well, and the state had indicated that the briefing was completed. And these witnesses, in particular, they were very difficult for us to serve as well. We don't know that we would be able to get them back. We had difficulty serving them through our process servers, and they were hard to find. And then there was also one who was released who was actually an out-of-state subpoena witness. And those also take additional time that we don't have at this point.
Appreciate it. Thank you.
Yes.
I don't know who's going to be arguing.
It's me, Your Honor.
Okay.
Thank you. May it please the court. Your Honor, the case that actually governs this court's analysis is State versus Harper. And in State versus Harper, the New Mexico Supreme Court at 211 New Mexico Supreme Court 44 paragraph 2 noted that exclusion of witnesses requires an intentional violation of a court order, prejudice to the opposing party, and consideration of less severe sanctions. And when considering sanctions, prejudice to the opposing party is a central consideration. And in Harper, at paragraph 19, the Supreme Court noted that even when a party has acted with a high degree of culpability, the severe sanctions of dismissal or exclusion of key witnesses are only proper when the opposing party has suffered tangible prejudice. And in this case, Your Honor, first, I would submit to the court that prosecutorial discretion allows the prosecution to make decisions with regard to the evidence it plans to present at trial. Unless that faith is demonstrated, those decisions are generally not subject to review. I would submit to the court that in this case, what happened, Your Honor, is that on May 6th, there were a number of witnesses disclosed. Because that was the pretrial motions deadline, the state had no idea the defense was planning to call these witnesses. So we filed this motion. But then these witnesses were set for pretrial interviews, the ones that the defense now seeks to exclude. These witnesses were interviewed. These witnesses, then the state investigated the statements of these witnesses and determined over a period of that weekend that it would be there would be no prejudice to the state. So we went ahead and withdrew the motion. And so what's important for the court to know, Your Honor, is that Mr. Zach Sneesby, which is one of the witnesses that the defense fortuitously decided to withdraw, actually was interviewed the week before the last week in May. And during his interview, he revealed that he was standing very close to Mr. Baldwin when he shot and killed Helena Hutchins. And Mr. Sneesby specifically said he saw Mr. Baldwin pull the trigger. And as you know, the defense position has always been that he didn't pull the trigger. Well, now there's an eyewitness who actually says he saw him pull the trigger. And he said this during his pretrial interview. The state conducted additional investigation and determined that it would then withdraw its objection or opposition to these witnesses. There was no bait and switch. There was no bad faith. And what's important, Your Honor, is that these were defense witnesses. It's not like these were state witnesses that were not made available for pretrial interviews. These were defense witnesses. Presumably, the defense had spoken to them, had investigated what they were going to say, and they disclosed them on their witness list. So for them to now argue prejudice is, I would respectfully submit, disingenuous, because they are seeking to exclude and claiming prejudice because they withdrew and didn't have time to set up pretrial interviews of their own witnesses. Well, if we're going to list witnesses on our witness list, we first interview them, find out what they have to say, and then we list them on our witness list if we believe their information or the evidence they're going to present is relevant. On May 6th of this year, the state filed its witness list. The 45th witness, as the court noted, is any witness disclosed by defense, called as a witness by the defense, or listed on the defense witness list. The fact that the state then listed the witnesses the defense sought to withdraw on its witness list does not result in a violation of the rule, because we did, as the court pointed out, the 45th witness was any witness listed or disclosed by the defense. Your Honor, with regard to the prejudice, because before the court can impose the severe sanction of exclusion, the court has to find that there is prejudice. At paragraph 19 through 21 of the Harper decision, the court specifically stated, and I quote, "The requirement that any serious sanction against the state be conditioned on a finding of prejudice is well established in our case law. Prejudice must be more than speculative. Therefore, when discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defense preparation for trial." These were defense witnesses, and that bears repeating. These were not state witnesses that the state suddenly disclosed a few weeks before trial. These were their own witnesses that the state put on the witness list on June 2nd. Therefore, Your Honor, under Harper, I would submit to the court that there has been no intentional violation of the court's order. In fact, there has been no violation of the court's order, and therefore the extreme sanction of exclusion is not justified. The state offered and continues to offer. We will agree to extend the pretrial interview deadline. If they wish to interview yet again, potentially their own witnesses, we have no objection to that. We have no objection to extending the pretrial interview deadline. And that would be the appropriate remedy in this case, Your Honor. With regard to the doctrine of judicial estoppel, I would submit to the court, Your Honor, that this is a doctrine that would not be applicable in criminal cases. And we cited to a case that could be analogous for that proposition, and that's State versus Arevalo. And that's 2002 New Mexico Court of Appeals 62 decision, wherein the New Mexico Court of Appeals refused or rejected the application of non-mutual collateral estoppel. And in that case, the New Mexico Court of Appeals, in citing Standifer versus United States, a U.S. Supreme Court decision from 1980, noted that the question whether the contemporary doctrine of non-mutual collateral estoppel basically is an unknown for New Mexico courts. Now, in New Mexico, with regard to criminal cases, the important interest in enforcement of criminal law and the public interest in the accuracy of justice of criminal results are not present in civil litigation. So what the defense is asking this court to do is to apply a doctrine from civil law to a criminal case. And we have different concerns, Your Honor. We have different concerns in a criminal case as we do in a civil case. And so as the court in State versus Arevalo rejected and refused to apply the doctrine of non-mutual collateral estoppel, this court must reject the defense invitation to apply this judicial estoppel doctrine to this criminal case. The state was not able to find any case where the doctrine of judicial estoppel was applied in a criminal case. And that's because, based on Arevalo, the appellate courts in this state would likely reject the application of that civil doctrine to a criminal case. But assume even if the court were to consider applying judicial estoppel, the state respectfully submits, Your Honor, that the defense has failed to meet the requirements. First, the party against whom the doctrine is to be used must have successfully assumed a position during the course of litigation. Now, the defense argues that there need not be a judicial decision. The state submits to the court that that is a prerequisite. And even the case that they cite to matter of state of Kuchan, at paragraph 14, the court specifically says, quote, under New Mexico law, a party successfully assumes or argues a position when the party takes that position before a judicial body, that position is at issue, and the party is ultimately successful. The Kuchan court cites to Wooten versus Vinson, and in that case, the court declined to apply judicial estoppel in a dispute over attorney's fees to the plaintiff's argument that the fees were reasonable, in part because the plaintiff did not ultimately convince the district court that her attorney's fees were unreasonable. This court had not yet ruled on the state's motion. So that prong of the judicial estoppel doctrine does not apply in this case. Counsel argues that, well, it's either a motion or have an order and the first prong is met. Given the language from the Kuchan case, the New Mexico courts, appellate courts, would likely find, and did find in that case, that there has to be some judicial decision as it relates to the position that was taken by the party. But assuming the court finds the first prong is met, I would respectfully submit that the defense has failed to meet the prejudice prong. And the judicial estoppel doctrine requires the defense to establish that they have suffered prejudice. There has been no prejudice in this case. Again, these were defense witnesses who were disclosed by the defense, presumably interviewed by the defense, and that's why they disclosed them, because they obtained information that they believe would be favorable to their position. So there is no prejudice in this case, and we're talking a very short period of time. And again, prosecutors' pretrial decisions carry or enjoy a strong presumption of regularity. Unless there has been a showing of bad faith, those decisions should remain in place, Your Honor. There is no prejudice to the defense as it relates to this particular issue. And as I noted, Your Honor, under Harper, the decision here would be to extend the pretrial interview deadline, allow for the defense to speak to their own witnesses, and any prejudice is cured. And we would respectfully request that the court deny the defendant's motion to exclude these witnesses.
Reply, Ms. LeBlanc.
Yes, Your Honor. I'd like to address a couple of the cases that the state has raised. First, with respect to Arevalo, State v. Arevalo. On this case, Your Honor, where they're talking about mutual collateral estoppel. Again, collateral estoppel is a different principle, but what the court was deciding in this case was there were two co-defendants, and they each had been assigned separate jury trial settings. At one jury trial setting, one of the co-defendants was found not guilty. Then the co-defendant who was set to go to trial second, then instead filed a motion for judgment of acquittal, asserting that because the other co-defendant was now found not guilty, that the same should apply to him. And so that was what the decision was, and the court, found that there was a lack of mutuality. So this is, a very different analysis than judicial estoppel. There is precedent, however, for the use of civil type doctrines or principles when we look at, for example, specific performance that derives from contract law. And we have cited cases in our motion as well that have to do with the proposition that when the state has made an offer of a plea agreement where the defendant detrimentally relies on that offer, even if it has not been yet accepted by the court, then the state has to engage in specific performance and leave that offer open. So there is precedent, Your Honor, for the inclusion of civil doctrines within the criminal context when it is appropriate. And in this case, it is appropriate in order to maintain the integrity of the judicial process. The other proposition that the state has put forth before the court was that was that basically criminal prosecutions and their discretion in initiating and conducting those prosecutions will not be disturbed, those decisions by the prosecutors. And for that proposition, they cited Blackledge v. Perry. And in this case that was cited by the state, actually the court did not say that the prosecutorial discretion would stand absent bad faith. They say the opposite. What they said was that even in the absence of bad faith, the state cannot indict on a felony after the defendant had been convicted on a misdemeanor and then appealed the conviction and got a trial de novo. And they said even where there was not bad faith, the prosecution cannot do this because, in fact, they don't want this to have a chilling effect on defendants who would be exercising their right to appeal. And so that is not accurate, that bad faith is the only way in which a prosecutorial discretion can be overturned. And I would ask the court to consider the fact, again, in the state's own words, in their motion that they filed on May 6th, the rules do not contemplate gamesmanship, and this court should not countenance such conduct. I will also point out as a couple of final points that the state talks about, the time the defense had to investigate this case. However, the state has had even longer. The state has had nearly 3 years to investigate this case. And somehow within that short window of, less than 48 hours between when the last witness had been interviewed on May 31st, and then the moment that the defense had had submitted its courtesy copies and filed its notices of withdrawal of witness and also its new amended witness list. Within that period of time, what changed? What additional investigation was had that didn't already take place before? They have told the court nothing about any of those specifics. What changed was that the defense revealed its position, and then they sought to take advantage. And in addition, the state says that they filed its motion to exclude as a placeholder motion. First, in order to file a motion, there has to be good faith. You have to have an actual basis to file a motion. The state in their motion claimed prejudice. That is different than a placeholder motion. If they're saying it's just a placeholder, then how are they making assertions of prejudice if it's just something there? So it sounds like the state is saying that those are just words that they included because that was the standard that they needed to meet, rather than actually determining that they had suffered prejudice because it was merely a placeholder. So we would ask the court, again, to grant the defense motion. Thank you, Your Honor.
Thank you for your presentations, counsel. The court makes the following ruling, which will be followed up by a written order. The court denies the expedited motion for order excluding witnesses. I did not think that the defense has demonstrated the prejudice that is required under State v. Harper. The defense was on notice that the state may call defendants' witnesses through their May 6th witness list addendum. And given this notice, the court does not find that defendant was prejudiced by the later filed June 2nd, 2024 witness list addendum. With respect to the judicial estoppel argument, that also is denied as part of this order because the doctrine is to prevent parties from playing fast and loose with the court by successfully arguing one position and then later adopting a position inconsistent with the first. And there, I don't think you've met the prongs of, first of all, they didn't successfully argue before the court, and also I don't think that there's the prejudice as contemplated by Cutchin. So you'll get these orders next week. All right, next up. All right, this is the state's expedited opposed motion for use immunity. And
that's me, Your Honor.
All right, Mr. Bowles was trying to get on. No, this isn't his.
Well, I was actually wondering why he wasn't on because he did file a response.
That's correct, Your Honor, and I believe the state's reply addressed both defendants' briefings as well.
Well, but there's an issue there because the defendant, Mr. Baldwin, does not have standing to oppose use immunity for Ms. Gutierrez. That's outlined in the case law. I can give you the case. It's State v. Brown.
Okay, I didn't even call this yet. I just mentioned about Mr. Bowles. So let me try to see if staff can get him on now. All right, next up is D1010 2024-13 State of New Mexico versus Alex Ray Baldwin. Again, this is the order denying state's amended opposed expedited motion for use immunity for Hannah Gutierrez, and parties that are arguing, state your name.
Carrie Morrissey on behalf of the state.
On behalf of the defense, it'll again be briefly Ms. LeBlanc, and I understand Mr. Bowles is on too. So I don't know if the court's waiting to hear from him.
Okay, go ahead, Ms. Morrissey.
So, Your Honor, as an initial matter, the defendant, Mr. Baldwin, has no standing to oppose use immunity of Ms. Gutierrez, and that's laid out in State versus Brown, 126 New Mexico 338. And I imagine that's the reason that their response indicated really that their complaint was that it wasn't timely and didn't really articulate any other objections. And that's because they're aware that they don't have standing to present any other objections. So to kind of back up, Ms. Gutierrez, as the court can see from the pleadings, was initially named on the state's witness list in February. She was then named on the defendant's witness list in April, and I believe she was also named on the defendant's witness list in May. She was scheduled for a pretrial interview after some difficulty, and I personally intervened and set up that interview, even though it was the defendant's responsibility. So we interviewed her, and as the court can see, when we interviewed her, I would certainly argue inappropriately, her attorney instructed her to assert her Fifth Amendment privilege to questions that did not trigger.
Just a minute. Is there a reason why the attorneys are not on video? Under our rules, you're required to be on video when we're doing hearings.
I'm sorry, Your Honor, I just kind of lost my train of thought. So she was scheduled for a pretrial interview. We interviewed her. Mr. Bowles instructed Ms. Gutierrez to assert her Fifth Amendment privilege when questions were posed to her that didn't really trigger her Fifth Amendment privilege. The state is not seeking information from Ms. Gutierrez about her criminal conduct. The state is seeking information from Ms. Gutierrez about the criminal conduct of Mr. Baldwin. The court can see from the transcript of the interview, at one point, Ms. Gutierrez just asserted her Fifth Amendment privilege without the assistant attorney. And when I mentioned to Mr. Bowles, I said, you're not really advising her to assert her Fifth. She's just doing it on her own. And he said, well, I think she can do that. So we have Ms. Gutierrez who doesn't understand the circumstances in which she gets to assert her Fifth Amendment privilege, just asserting it, and her attorney not counseling her on that. So the bottom line is, it took a long time to schedule the pretrial interview. That's the fault of Mr. Baldwin's counsel and Ms. Gutierrez's counsel, not ours. They listed her, I believe, initially on April 19th. We requested her pretrial interview on April 21st. We didn't create any delay at all. Her interview was scheduled, and Mr. Bowles did exactly what Mr. Baldwin's counsel wanted him to do, which was just have her assert the Fifth to everything, because they don't want her to testify. She is listed on their witness list, and they presented her for a pretrial interview, but they don't want her to testify. They want to get her statements in as exceptions to hearsay. And certainly what the state is arguing to the court is that the hearsay statements that the defendant wants to present to the jury, those are statements that have to do with Ms. Gutierrez's culpability, and they are absolutely exculpatory to Mr. Baldwin, and they go to causation in this case. It's perfectly appropriate for them to present those statements. I'm not objecting to that or arguing that point at all. But what I am saying is that in turn, the state is also allowed to present testimony from Ms. Gutierrez that goes to Mr. Baldwin's culpability. She has probably more information than any other witness with regard to Mr. Baldwin's culpability. We are simply asking that we also be able to present testimony and evidence from Ms. Gutierrez. The defendant intends to do it. There's no question about it. So the first thing that needs to happen here is we need to have some kind of a question by question determination from the court as to which questions Ms. Gutierrez even can lawfully assert her Fifth Amendment privilege. Once the court decides, okay, this is the category of questions where I believe she can assert her Fifth Amendment privilege, then we make a determination about whether or not she should have use immunity to answer those questions. That's not terribly difficult. Her pretrial interview, as the court can see, was relatively short. I think it was 20 or 30 minutes. So we need to have a hearing. We need to have the court determine, or the court potentially could even do it from the transcript. Have the court just determine what she needs immunity for. At this point, a lot of the questions that we would ask her, she doesn't even need immunity for. She's just a normal witness. She's on the witness list. She's been interviewed. We put her on the witness stand. We ask her the questions, and she's required to answer them under penalty of perjury. There's no reason when she's posed a question, for example, was Mr. Baldwin attentive during the firearms training that you provided? How does that trigger her Fifth Amendment privilege? What did your firearms training with Mr. Baldwin consist of? How does that trigger her Fifth Amendment privilege? So this is just something that we need to get ironed out so that the jury can have all of the information that the jury needs, that the jury is entitled to, And we don't create a situation where Ms. Gutierrez's statements only come in with regard to the exculpatory value they have for Mr. Baldwin. They also need to come in with regard to the inculpatory value that they have with regard to Mr. Baldwin. Thank you.
Mr. Bowles, sorry.
Your Honor, and as a preliminary matter, Judge, can you hear me?
Yes.
Judge, I want to make sure. Okay, I'm having poor internet connectivity, so I hope this doesn't affect it. Judge, I want to start by saying that first of all, the assertion of privilege was on behalf of Ms. Gutierrez-Reed, who wanted to assert her privilege. It wasn't on behalf of anybody else. She has a currently pending appeal, as this court knows, so she has a conviction that is not yet finalized, and the cases are very clear. She can invoke a privilege as to questions that may tend to incriminate her. I agree with the state. She cannot invoke as to all questions if those do not have a tendency to incriminate her. However, when Ms. Gutierrez-Reed invoked it on her own at the interview, Ms. Morrissey also said in the transcript, and she left that out in the interview, I think she can invoke that. So that's what happened there. That was May 14th. Your Honor, preceding May 14th, on or about May 8th, it was a confusing situation because Ms. Morrissey had told me that on a Sunday, an email that she would stipulate to unavailability, or thought she would stipulate to unavailability, so that the statements can come in through that exception. So I thought it was going to be a stipulation. Then there was confusion on the interview date. Then I had scheduling issues, so we got it set up. Next, Your Honor, on May 14th, we got the indication from Ms. Morrissey that she wanted to file a motion to force use immunity, which under Rule 5-116, this court unquestionably has that authority and discretion to do that. Now, Your Honor, in a normal case, and the cases cited in that rule, Bellinger and some others, this court can force use and derivative use immunity, which I do not believe should be selective, as the state indicates, because the problem we get in there is that on cross-examination, questions may be asked, then Ms. Gutierrez-Reed may have to invoke in the middle of trial. If that were to happen, her testimony could be stricken. So I think if this court were to order use and derivative use immunity, it would have to be blanket as to the trial testimony and cross-examination, I would submit, to avoid those issues. But Your Honor, that's in the normal case. This will be most likely the most publicized trial in the history of New Mexico, or at least one of them. And because of that, we have submitted in our briefing, this is not the typical case. If Ms. Gutierrez-Reed testifies, there's no current restrictions about what could be asked of her, including on cross-examination. That testimony will undoubtedly be watched by millions of people. Currently, Ms. Gutierrez-Reed is set for trial in front of Judge Ellington in August. We have moved to continue that, Your Honor, but that is a separate matter involving alleged bringing a gun into a bar. There's no protections as to Ms. Gutierrez-Reed on that trial, because even if this court were to order use and derivative use immunity completely, that testimony she gives will be watched and heard by potential jurors, and there's really no way to prevent that. Now, the government says we can do a motion to change venue if there's an issue. But again, that raises the issue, Your Honor, this is going to be widely publicized across not only the state of New Mexico, but the country. So that's a very real concern Ms. Gutierrez-Reed has. She's also, and the state really didn't touch on the separate Ellington trial, Judge Ellington trial, but that is a very real concern of hers, that if she's asked on cross-examination questions related to that, it really imperils her ability later to defend herself in that proceeding. We also have the appeal, Your Honor, which we don't know what will happen on that, but if it's remanded, the state gets a complete opportunity to cross-examine or examine Ms. Gutierrez-Reed on matters she would have never had to say going into that trial. So while the court unquestionably has the discretion, I would submit, Your Honor, that because she is unavailable and statements can be introduced by both parties, there is another way the court can handle this and avoid the potential constitutional issues that may arise in the future with her right to a fair trial in front of Judge Ellington and perhaps in front of this court if the appeals court reverses this case. So I think there's another way this could be handled for the testimony to be obtained by both parties.
I'm going to allow the defendant to respond. I think that under State versus Brown, they can take a position. Let me read that case. All right, so I think that you can oppose the motion. And I'm going to listen to it. Go ahead.
Yes, Your Honor. So I will be brief. The issue that we have is with respect to the prejudice due to the timing of the state's request for use immunity. As the state has noted, Ms. Gutierrez-Reed was actually on the state's witness list as far back as February. She was also on the defense witness list. And the state could have made this application months ago because the situation is that Ms. Gutierrez-Reed did not testify in her own trial. And so there were no new statements that were available to the state after the trial that were not already available to the state for the past nearly 3 years. So they were aware of the situation. And they even, it sounds like from Mr. Bull's representations, the state even indicated that they were willing to stipulate to unavailability without taking her statement, which would have then, resulted in, the same position we would have been in without the grant of use immunity. But the state was aware of this. They were aware of this 50 witnesses ago. They were aware of this 3 years ago, and they had her listed. So at this point, the state now, as they're making all of these many numerous disclosures, they disclose us all of these, phone calls from Ms. Gutierrez-Reed, again, that we cannot possibly have the time to go through in advance of a pretrial interview of her, because what the state is indicating is they think she has much more information than the statements that have already been provided. But we don't have access to those statements. We would need to interview her. So she's effectively becoming a new witness that now we would have to interview and prepare for her at trial. And so the state had every ability to do this sooner. And we would ask that the court consider some of the items that were also in, that I know were contained in some of the other filings that the defense has submitted with respect to the volume of new disclosures that the state has made and the prejudice that the defense will suffer if we now have to approach this new, rather substantive witness when we're talking about just 10 days, 10 business days before trial. Additionally, the state has indicated that they requested her interview right away and they weren't responsible for any delay. I think that needs some clarification, Your Honor, because the defense initially had subpoenaed Ms. Gutierrez-Reed for a statement. There were some scheduling issues based on availability. The defense actually was working with and contacting the prison facility, and we did have that set up, but then the interview had to be canceled based on availability of Ms. Gutierrez-Reed's counsel, and she does have a right to have counsel present. So that had to be moved. In the interim, as we were setting up the next one, Ms. Morrissey indicated that she wanted a deposition instead of a statement. And so she needed to file a petition before the court. The defense took no position on that, but informed Ms. Morrissey that if that's something that she wanted, she would need to petition the court for that, as is the appropriate criminal procedure under the rules. She did not do so, but that did cause part of the delay. And then ultimately the interview was scheduled with Ms. Gutierrez-Reed, did take place, and the defense also provided the information to the prison facility with the links for her appearance. And so we would just ask the court to note that there was nothing that prevented the state from petitioning this court for use immunity. And that is our sole objection at this stage, is the fact that they could have done this while we still had the time to conduct a full investigation of what her statements would be without prejudice to the defense. But now here we are in the 11th hour on the eve of trial, and the state is making motions for use immunity that will basically provide this witness who would be one of the most significant of the trial. And we are definitely prejudiced by this late request, and we would ask the court to deny the state's application for immunity, at least specifically with respect to the timing and the prejudice that this would cause the defense of Mr. Baldwin at this stage. And he is entitled to a fair trial and to an opportunity to prepare and present an adequate defense.
All right, before you reply, I have a question for Mr. Bowles. Is she going to use that use immunity, or does she just plan to not take advantage of it?
And Your Honor, I really apologize. It noted that my internet was having connectivity. I heard part of the court's question.
Does Ms. Gutierrez, all right, does Ms. Gutierrez, to your knowledge, have any intent to answer the questions if given immunity based upon that? I mean, I'm looking at the interview. She didn't cooperate.
Your Honor, she doesn't want to be cooperative in this case. I understand the court can order under use immunity, blanket use immunity testimony, but she does not want to answer the questions.
Reply, Ms. Morrissey.
Your Honor, if the court were to grant the motion for use immunity and Ms. Gutierrez were to refuse to follow the court's order, then she's held in contempt of court. Witnesses don't just get to refuse to follow the court's order. She refuses, she's held in contempt of court. We will be asking for additional jail time. That's how this goes. I will start by, it's baffling to me, absolutely baffling to me, that there is a defense attorney in this hearing opposing immunity for his own client. If that is not an indication that he is acting as an arm of Mr. Baldwin's defense team, I don't know what is. And listen,
Your Honor, that's inappropriate.
I think it's absolutely true.
Okay, let's move on.
It's
keep
actually
going.
not.
You all, it's her turn. Let's keep going.
Mr. Bowles has told the court, look, it's really complicated, Judge, for us to do it the right way, for us to put her on the witness stand and have her, outside the presence of the jury, or set a hearing and have her outside the presence of the jury, figure out what she can answer and what she can't answer. So you have to do it blanket. Okay, do it blanket. I'm not opposing that. Mr. Bowles' suggestion, if that's what he thinks is the best way to do it, you can absolutely issue blanket use immunity. She has to answer every single question under the court's authority. If she doesn't do it, she suffers the consequences of that. Mr. Bowles continues, even in the Baldwin case, to present information to the court that is patently false, and he's doing it again. He is in this hearing telling this court that these lawyers, the defense attorneys and the state, are going to be able to ask any question of his client. Well, the rules of evidence only permit us to ask relevant questions of his client. Every lawyer who questions Ms. Gutierrez at trial will be subject to the rules of evidence, will be permitted only to answer appropriate, relevant questions, those questions that are determined by this court to be appropriate. The Ellington case is just a red herring. There is nothing about that separate case that is relevant to this case at all. I would be stunned if the court found otherwise. This is a completely different thing. It didn't have anything to do with with her participation on the movie set. She was in the city of Santa Fe as just an individual. She wasn't working, and it's absolutely ridiculous. Not to mention the fact that Ms. Gutierrez has another case pending in front of Judge Ellington because of her own conduct. So we don't turn around and say, state, you can't use her as an incredibly important witness because she's got this other case pending. She has another case pending because she seems to have committed additional criminal offenses. That's kind of the way it goes. With regard to Mr. Baldwin's argument that there is prejudice based on the timing, let me tell you, Judge, I was not aware that I was going to need a motion for use immunity. I was not aware that Mr. Bowles was going to show up to a pretrial interview and instruct his client to assert her Fifth Amendment privilege to questions that do not trigger the Fifth Amendment privilege assertion. Now, based on my experience with Mr. Bowles in the Gutierrez case, maybe I should have anticipated that, but I did not. So I didn't learn of that until we finally got the pretrial interview done. Ms. LeBlanc's statement about the short period of time that the state was considering asking for a deposition, that didn't create any delay at all. At that point in time, Ms. Gutierrez was already scheduled for a pretrial interview. That pretrial interview was never canceled up until Mr. Bowles indicated that he had scheduling difficulties. So the pretrial interview was scheduled. We talked briefly about having a deposition. We reached out to Mr. Baldwin's counsel. We asked for their position on that. They said they took no position on it. And I said, okay, I guess we'll set her for a deposition. Then they said, no, we're not opposing it, but we think that you need to get the court's approval. I'm not creating that delay. They're creating that delay. And at the end of the day, we said, look, we'll just go ahead and interview her on the day that she set, which was May 9th. Actually, I think it was May 10th. So we agreed we'd go ahead and interview her on that day. The interview was never canceled. Mr. Bowles canceled the interview. We got her scheduled on the 9th. Mr. Bowles canceled the interview. We were trying to get her reset. And because I sort of had this feeling like if you want something done right, you better do it yourself, I did it myself. And I finally ended up getting my pretrial interview, wherein Mr. Bowles unlawfully instructed his client to assert her Fifth Amendment privilege to nearly every single question that was asked of her. So to say the state should have just been able to anticipate this roller coaster ride is absolutely ridiculous. Now, with regard to the jail calls were provided weeks ago. I know how long it takes to listen to the jail calls because I've had to pay my investigator to do it. There are 2 lawyers on the state side. There are 10 lawyers on the defendant side, and they have at least 1 investigator. So if they can't get that under control relatively quickly, I'm not sure what to say. We are not, I want to make clear, we are not asserting that Ms. Gutierrez has a whole bunch of additional information that nobody's ever heard of. She is specifically being called by the state so that she can simply give the jury the information that she already provided to law enforcement and to OSHA with her lawyer's advice to waive her Fifth Amendment privilege. So those are the things that we're asking to get in through her testimony. There's one other statement that she made in a jail call that was specifically provided to the defense. They don't need to go listen to 300 and some of them to find that. We gave them the number. We showed them exactly where it was. Now, at the end of the day, when the defendant comes to court and says, Judge, we don't have enough time, we're prejudiced because we don't have enough time, I want to take the court back to the hearing that we had on February 20th, where we were talking about scheduling, and the court suggested that the trial be scheduled in October, and the state suggested that the trial also be scheduled in October, and it was Mr. Spiro, it was the defendant, who said, no, we need to have a trial in June. They wanted a trial last month. They got a trial this month, and they continue to come to court and say, Judge, we don't have enough time. They don't have enough time because they asked to have the trial set too soon in a case that has massive discovery. With regard to any of their complaints about all of these documents that have been provided, I have to tell you, Judge, when they indicate in their arguments that they received this massive amount of discovery, what happened was we realized that not all of the lapel videos were in our possession and therefore were not in the defendant's possession. So as soon as we realized that, we got those videos from the sheriff's department, we uploaded them, we provided them, and we realized that the vast majority of those videos were duplicative. So what was happening is 2 police officers were conducting an interview. The defendant didn't have the lapel camera from one of the officers, but they did have the lapel video from the other officer who was present for the interview. So a lot of their complaints about this stuff was coming in late, they're really over exaggerating any potential prejudice that they could have possibly had from any of that. And again, they asked for a June trial because of my objection. The court gave them a July trial when we were intending to have an October trial. So if they don't have enough time, there is a remedy. They can ask for a continuance. Thank you.
All right, the court makes the following ruling to be followed up by an order of the court to be filed next week. The state denies the state's amended opposed expedited motion for use immunity for Hannah Gutierrez. It's pretty clear that she does not intend to cooperate. The court may grant use immunity pursuant to Rule 5116 if the court finds the testimony may be necessary to the public interest and the person has refused or is likely to refuse to testify. So it's really the public interest portion that I'm going to address because she has indicated that she won't testify. You've indicated that she possesses information about what she already told the investigators. I don't think that there is anything that, I haven't heard of anything that she might testify to that someone else could not testify to, even about her observations. Maybe the only portion is that talking about how Mr. Baldwin didn't want to be trained, things like that, which she could probably answer without the use immunity. But, the state says, well, the simple solution after she refuses to answer, even though she's been given immunity, is that you can hold her in contempt. I'm not going to do a mini trial within a trial. And I think that when all is said and done, if she's going to be an unavailable witness, then we're at the 11804 evidence rule on unavailable witnesses. So I think you should prepare accordingly.
If I could just ask a point of clarification.
Yes.
Given that the court is denying the motion, the state still can ask questions of Ms. Gutierrez that do not trigger her Fifth Amendment privilege. So we can still have her transported. We can still put her on the witness stand. Does the court want to deal with what questions she has? She has the right to assert the Fifth to prior to trial, or do you just want to wait and do it then?
Right. I'm forecasting based upon what Mr. Bowles is saying, based upon that interview, that everything is going to be a non-answer, and then there's the unavailability of the witness.
Well, and we certainly will be renewing our motion, but I hear your ruling, and I'm not arguing with it. Thank you.
All right. Thank you. We're in recess in this case. Do you all want to take a break, or are we continuing? I see nods, but I don't know what that.
I would like a break.
Whatever's preferable to the court.
Okay, we'll take a what time is it? 10. We'll be back at 11:15. Okay. Thanks. Bye bye.
Thank you.
All right, we're back. I see that, I see that in Odyssey, the motion to dismiss indictment for destruction of evidence is listed twice. I think the first one is supposed to be the full and font.
That's our understanding too, Your Honor.
Okay, good. All right. All right, state's motion for in-camera inspection of joint defense agreement. The court is ready, state.
Your Honor, at this juncture, I believe, this is Erlinda Johnson. At this juncture, the counsel for Ms. Hannah Gutierrez-Reed responded that there is no written joint defense agreement. And so unless there is a written joint defense agreement, I think that moots the state's request for the court to inspect any joint defense agreement.
So on the record, are you withdrawing your motion?
Yes, Your Honor, but we would like confirmation from the defense that there is no written joint defense agreement.
Well, notably I'm sorry.
So confirmed.
Okay, so confirmed. All right.
So the state would be withdrawing that motion at this time.
Okay, please prepare that paperwork.
Thank you.
All right, let's go into the full and font motion if we're ready. Are we ready?
We are, Your Honor, and I will be handling that with the court's leave for the defendant.
All right, thank you. All right, so the motion is, get my motions here. All right, this is the motion, defendant Alec Baldwin's expedited motion for motion to dismiss the indictment for failure to allege a criminal offense. Okay, thank you. Go ahead.
Thank you, Your Honor. I haven't appeared before you before. My name is John Bash. I'm one of the attorneys representing Mr. Baldwin, and it's a pleasure to be here. One bit of housekeeping before I begin. I know we have a motion later today that involves witnesses. If you had a sense of when that will be, we can go ahead and start notifying the witnesses to be ready at a certain point in time, if that would be helpful to the court.
I believe after the lunch hour, this is probably going to take us to noon Mountain Time, this motion, or if it doesn't, we'll break at noon. And in other words, I'll call you back at 1, basically. Okay. Mountain Time.
Thank you. Thank you, Your Honor. And with that, I'll begin. May it please the court.
Yes.
We have moved under Rule 5601D to dismiss the indictment for failure to state a crime. And our submission, Your Honor, is pretty simple. Under State versus Henley, which is the New Mexico Supreme Court's authoritative construction of the involuntary manslaughter statute, that's at 2010 NMSC 39. In order to convict a defendant of involuntary manslaughter under New Mexico law, the state must establish the defendant's subjective awareness of a substantial risk that his or her actions could cause harm to another person. It's a subjective standard. It differs in that respect from certain other recklessness offenses under New Mexico law. And our submission, the state, and I think we will show this, has abjured any ability to show that Mr. Baldwin had a subjective awareness of a risk that the firearm in this case was loaded with live ammunition. Without that essential piece, the state cannot establish the element of the offense. It's not a question, Your Honor, of evidentiary sufficiency. It's not a question of how different fact finders could view the facts. It's a logical, legal question. The state has said that guns kill people. That's true. They kill people when they are loaded with live ammunition. If the state cannot even allege the essential piece that he was subjectively aware of a substantial risk that it was loaded with live ammunitions, they cannot prevail. Now, Your Honor, there has been a dispute between the parties about the extent to which the state is bound by its factual assertions in the Gutierrez-Reed trial, and I'm going to go into that in a little bit. But I don't think the court actually even needs to address that dispute, because the state's concession is on the face of the opposition that had filed to this motion. I direct the court's attention to pages 14 and 15 of that opposition. I think it was filed on May 21st. In response to our argument that they can't prove, and they haven't even alleged, that Mr. Baldwin was subjectively aware of a substantial risk that the gun was loaded with live ammunition, they don't say, yes, we can. And I'll get into this more in a second, but they say two things. They say, well, if he had done that, we'd be charging him with second-degree murder. That is a concession that they do not think he did that they cannot allege that, and they cannot prove that. Second, they point to a bunch of other stuff he did. And we'll talk about that, but none of that other stuff poses a danger to another person unless there's live ammunition in the gun. None of it does. They can't prove that element of the offense. They don't even claim to, and it's clear on the face of their opposition brief. So let me talk just briefly, Your Honor, about the full and font standard, because I know you're intimately familiar with it, but the parties have joined issue to some degree on what that standard provides. And the state's wrong about this, and I just want to clarify why they're wrong about it. The original full and font case back in 1995, as I'm sure the court knows, said there was a distinction between questions of fact and questions of law, and that a pretrial motion to dismiss under, I think back then it was 5601B, now it's subsection D, was only proper for questions of law. And the state kind of clings to this distinction between questions of law and fact. But critically, Your Honor, in 2016 and 2017, in the Pacheco and Platero cases cited in our brief, that's 2017 NMCA 83 and 2017 NMCA 14, the Court of Appeals rejected the distinction between questions of fact and questions of law. And you can see why. It's in any case where it's a question about the application of law to facts, you can always frame any particular issue as a question of fact or a question of law. So it's an unhelpful distinction. What the Court of Appeals said instead is take the undisputed facts in the case, whether alleged, whether the state stipulates to them, doesn't dispute them. Take those undisputed facts and ask, can the state on those undisputed facts satisfy the elements of the offense? And what the guidance that the Court of Appeals gave in Pacheco was that typically that inquiry will turn on this question. Can the state reasonably assert the availability of additional evidence to satisfy the elements of the offense? So it's no longer, Your Honor, an issue of whether it can be characterized as a question of fact or law. It's a question similar to motions to dismiss in the civil context of whether the undisputed facts show that the state cannot satisfy the elements of the offense. And just to tie the loop on that, the state suggests that mental state questions like recklessness, knowledge, intent can never be the subject of a successful full and font motion. That is incorrect. In the published 2013 decision in Moreda, which we cite in our briefs and is at 2014 NMCA 60, the Court of Appeals did an intensive analysis of the facts alleged by the state to determine whether a full and font motion should be granted on a recklessness issue. There it was abuse of a nursing home patient by a doctor. So it is just not true that mental state can never be the subject of a full and font motion. It is true that it rarely is, but you rarely have facts like this where the state doesn't even allege that the crucial link between action and someone getting hurt, that the defendant had subjective awareness of that crucial link. That's pretty rare, and that's why this case is different. So, elements of involuntary manslaughter, and I don't think the state disputes this point. Under Henley, and the Henley case says this twice on page 108 of the Pacific Reporter, the defendant has to have subjective knowledge of the risk, of the substantial and unjustifiable risk that his or her actions will cause harm to someone else. I don't think that's disputed in this case. The state can correct me if I'm wrong. Critically, that's different than the way recklessness works under a lot of other statutes of this state. For example, the child abuse statute, which the Supreme Court just addressed a few months ago in the Taylor decision, has an objective standard. So it's what the defendant should have known. That's not true on involuntary manslaughter. The Supreme Court has been very clear about this. It requires subjective knowledge. What did the defendant actually know about the risk? So just putting those two things together, the full and font standard and the elements of involuntary manslaughter, The state's position cannot work logically. On pages 14 and 15 of their opposition brief, in addition to numerous statements they made on the record in order to secure a conviction of Ms. Gutierrez, their position is that no one could possibly know that there would be live ammunition on this set. They do not intend to argue, if their briefs and filings and statements are to be believed, that Mr. Baldwin had any subjective awareness of a substantial, not just any risk, a substantial risk that that firearm was loaded with live ammunition. If not, they can't show that he was aware of a substantial risk that whatever he did, whatever they allege he did, could kill somebody or could harm somebody. Because a gun does not kill people unless it has live ammunition. It just doesn't work. It doesn't make sense logically, and they have no answer to that basic problem. Now, we've given the court a number of cases from New Mexico and elsewhere analyzing involuntary manslaughter in the context of a particular weapon or object. And although the postures were slightly different, the basic question was the same. Can these facts enable a reasonable jury to find involuntary manslaughter? And the courts closely analyzed the nature of the object. In one case, it was a knife. In one case, it was concrete, and what the defendant knew about the object, and found and analyzed it that way. And the same analysis has to be done here. And if the state doesn't, as they don't, contend that he had any idea there was live ammunition in that weapon, he is not guilty. He's not guilty as a matter of logic and law. And the trial is not going to be able to overcome that. Whatever other things they alleged he did, if he didn't know it had bullets in it, he cannot be guilty. If he didn't know the substantial risk that it had live ammunition in it, he can't be guilty. Now, the state, Your Honor, essentially has three responses to this, and I'll just go over them briefly. One, the state links its position to an unpublished decision of the Court of Appeals in the Serna case. And in that unpublished and therefore non-precedential decision, the court canvassed a number of standards that it had previously used to resolve full and font motions. And the first one it canvassed or discussed was the question of fact versus law, and it said the defendant would lose on that standard, and the question in the case was recklessness in connection with reckless driving. But as I've discussed earlier, that standard has now been rejected in published decisions in Pacheco and Platero. So that is not a good standard. That was a non-precedential decision. It went on to apply the correct standard in the alternative, which was whether the undisputed facts show that the state cannot prove its claim. And there the facts were clearly disputed. The state disputed whether she had accelerated when she hit the pedestrian. There were disputes. Here, of course, at trial, we're going to dispute a lot of facts if it gets to a trial. But for purposes of this motion, we can take all of the state's factual assertions as undisputed, but they simply have not claimed that they can prove he had a subjective awareness of a substantial risk that the firearm had live ammunition in it. The second thing the state says, and they've said this a few times now, Your Honor, they say, well, if he had that knowledge, it would be second-degree murder. Okay, so a few things on that. One, they're just wrong about that. Second-degree murder requires a strong probability of death. If he knew there was a strong probability that there would be live ammunition in the gun and he fired it and pulled the trigger, which of course we dispute, that would be grounds for a second-degree murder charge. But substantial risk is a lesser standard. There's a significant delta between substantial risk and strong probability. So what they need to prove for this charge is that there's that he was subjectively aware of a substantial risk that the firearm contained ammunition. They don't even claim they can prove that. That's why it's not involuntary involuntary manslaughter. The other point on that, Your Honor, is that there's no rule that says any given factual scenario has to be able to satisfy every gradation of homicide. I mean, there are certain scenarios that are murder or nothing, based on the facts. And even if they were correct, which they're not about the second-degree murder point, that would not establish that they can show involuntary manslaughter without showing anything about his subjective awareness with respect to the risk of live ammunition. What's really, I think, telling about the second-degree murder argument is what I alluded to earlier, which is that argument shows that the state does not contend it can prove that he was subjectively aware of a substantial risk that the firearm contained live ammunition. They said it in black and white. We would have charged him with second-degree murder if that's what we thought. They can't prove it. They don't pretend to prove it. As a logical matter, they simply cannot prove the legal elements of this offense. The last point they make, Your Honor, is they refer to a bunch of other alleged actions by Mr. Baldwin. And they say that those alleged actions are enough to satisfy the elements of the offense. So there's two things to say about that. One, none of those alleged actions pose a substantial risk to the life of another person if the gun is not loaded with live ammunition. They say he knew it was a real gun, okay? They say he pointed it and pulled the trigger. They say he didn't participate in a safety check. Again, this is not a civil suit under the ordinary negligence standard. This is not a suit for violation of the SAG guidelines. This is an involuntary manslaughter charge. And under this state's law, that requires subjective awareness that what he's doing poses a substantial risk that it could kill somebody. Pointing and pulling a trigger when you have no awareness that the gun has live ammo in it, that there's no risk that it has live ammunition in it, does not pose that risk. Admittedly, this is an unusual case. Most people, when they encounter a gun in their home or somewhere, have reason to believe it might have ammunition, because ammunition typically goes with firearms. They're often preloaded with ammunition. In the typical defendant case, they're going to know that. But the reason the state won't allege that here is because it was a movie set, and this was a prop. And he was told by the people responsible for it that it was a cold gun. And the state told the jury, in order to secure a conviction of Ms. Gutierrez, that everyone on set believed it was empty. They told them that. They cannot come into this trial and say that he was subjectively aware. And to their credit, that's why they're not arguing that, because they can't. They know that's not true, and they know it would contradict what they said. So those are their three arguments. I want to briefly, and I just touched on it, talk about their prior representations. As I said, I don't think the court, to resolve this motion in our favor, even needs to get into that, because I think the state has effectively conceded in their opposition brief that they cannot prove that he was subjectively aware of a substantial risk that the firearm contained live ammunition. I think that's enough. But if the court does get into those prior representations, we've given the court a number of federal cases saying that it's a due process violation for prosecutors to take inconsistent views of the facts in two different cases arising out of the same event. Of course, there's exceptions if new evidence arises. For example, if they got an acquittal in the first case and they realized, no, we were wrong about that, we're going to take the jury's views to heart, and we're going to reassess our understanding of the evidence. That's not what happened here. They used a series of representations to secure a conviction of a person. And they sort of stunningly come into this court and say they're free to walk away from those and adopt totally factually inconsistent positions. I was head of a prosecutor's office for 3 years right across the border from El Paso to Austin. And I can't imagine us ever saying in a court filing, we can take diametrically opposed positions on the facts of two criminal defendants. I would never have let an AUSA do that. We've quoted them in our brief, and I won't go on extended about all the ways in which what they're saying now is inconsistent, but just a couple, Your Honor. In their opening argument, and this is at Exhibit F of our motions in this case, they told the Gutierrez jury in opening that the prospect of live ammunition on that set was incomprehensible. You can't square that with saying that he had a subjective awareness that what he was doing could kill somebody. It was incomprehensible to everybody. They said it's a hard and fast industry rule that live ammunition should be miles away from a film set at all times. They said the gun was checked right before it was handed to him. This was in summation. Ms. Morrissey told the jury in order to secure a conviction of somebody that when Halls announced cold gun, that led everyone to believe the gun contained only dummy rounds. She said the crew didn't believe there were live rounds on set. They believed that she was going to do her job. They believed that she did her job. She said, imagine I hand you a gun and I tell you it's basically empty and I walk away when in fact I put live ammunition on that. None of that is consistent with saying Mr. Baldwin had any subjective awareness that anything he did with that gun could hurt somebody else. It's totally inconsistent, and they should not be in the business of adopting factually inconsistent positions. Just a couple more, Your Honor, and then I'll get close to wrapping up my presentation because I know we have a lot to do on today. They've been inconsistent in other ways. In summation, the prosecution said it was completely foreseeable that Mr. Baldwin would manipulate the gun the way he did. But now they're saying that what he did was so out of bounds as to satisfy the standard of criminal recklessness. even though they said it was totally foreseeable on a movie set that he would do that. They said Ms. Gutierrez-Reed had no supervisor when it comes to weapons and gun safety on the movie set. But now their claim is that Mr. Baldwin should have micromanaged her. At least I think that's their claim from these new producer theory allegations. So the state has been inconsistent. As I said, Your Honor, I don't think you need to go there because I think they've made clear on the face of their opposition brief that they will not try to prove that he had a subjective awareness of a substantial risk that the gun was loaded. They just don't think they need to prove that. And they said, well, we would have charged him with second-degree murder if that's what we thought we had to prove, or if that's what we thought he did. Two other quick ones. A lot of their brief, Your Honor, is focused on the SAG guidelines, and it's a very, very strange sequence of arguments because they spend a number of pages saying that he was supposed to attend the check under, it's like Rule 12 of the SAG guidelines that are in the record. But I mean, if you just look at the face of this rule, it says the actor may attend the check. And if you look at the testimony they solicited from their own expert, Carpenter, at Gutierrez-Reed's trial, he said this is just a dog and pony show, or it's to give a warm and fuzzy feeling to the actor. It's not necessary. And then you get about halfway through their brief, and all of a sudden they say, well, yeah, it's true. They don't actually require this. But this isn't a trial under the SAG guidelines. I mean, all that's right, but the SAG guidelines are totally irrelevant to this. I mean, whether he did the thing he can elect to do under the SAG guidelines has nothing to do with his subjective awareness that that gun in his hand could kill somebody. They also say, well, he's different than every other person on that set, every other producer, because he had the gun in his hand. He's not different in the respect that matters for this element, which is, did he know that the gun in his hand could kill somebody? If anybody on that set knew the gun in his hand could kill somebody, they would have said, oh, stop. This is crazy. And that gets, I think, to my final point before I briefly address this new producer theory, which is that each of the actions, Your Honor, that they say shows his recklessness and shows that they can satisfy the elements of the offense, pointing the gun allegedly at somebody and pulling the trigger, not attending the safety check, he knew it was a real gun, all those alleged facts that they assert in their motion. It's not only that they don't they don't satisfy the element of subjective awareness, it's that they cut exactly the other way. No one thinks Mr. Baldwin or anyone else on the set wanted to hurt anybody. The fact that they assert, some of this we can test, but the fact that they assert that he was pointing and pulling the trigger, that confirms that he had no subjective awareness that there was a live round in the gun. No one thinks he wanted to hurt anybody on the set. The facts they cite as satisfying their burden under that element show exactly the opposite. They show that they absolutely cannot show that he had a subjective awareness that that gun could kill somebody. No one thinks he would have pointed and pulled the trigger if he knew that, if he knew there was any risk of that. So the facts they cite show exactly the opposite of what they cite them for. Last point, Your Honor, they've raised this new producer theory. It's not totally clear to me exactly what they're saying, but I think they're saying one of two things. The first one is they might be alleging some sort of supervisory liability, even if Mr. Baldwin had no awareness. He was negligent in supervising Ms. Gutierrez-Reed. Now, there's a ton of factual problems with that. That wasn't his responsibility, but those are not relevant for this motion. What's relevant here is that there is no supervisory liability criminal statute. You can't establish the mens rea, the subjective awareness based on a supervisory theory. That can't possibly work. The other thing they might be saying is that he should have known the gun was loaded or something. They haven't articulated this, but it seems to be what they're saying. But again, it's not that standard. He must be subjectively aware. He must have subjective knowledge of the risk. And that's clear as day in Henley. That decision's controlling. And for that reason, they can't meet their burden on this. So we reserve time for rebuttal, of course, but we respectfully ask this court to dismiss these charges because Mr. Baldwin is innocent as a matter of law. Thank you.
All right, before the state responds, I have a couple of questions over some of what you presented. So you said that that you can take the undisputed facts under full and fought. And I'm interpreting that to mean that you can ignore the disputed facts. And I don't read full and fought to be that.
No, Your Honor, the way I would describe it is you give the state everything they're alleging. So some of those facts are undisputed and some of those facts may be disputed. So for example, there's a dispute about whether he pulled the trigger. Give the state that, obviously not at the trial, but for the purposes of this motion, give the state those disputed facts. Assume they can prove. The way Pacheco describes it is is there a reasonable probability that they can obtain evidence to prove those elements? So if they, as long as it's not totally ridiculous, if they say this is a disputed fact, we think he pulled the trigger, give them that for the purpose of the full and font motion. Can they prove the elements even with that? And our submission is that no, they cannot, because they don't even attempt to allege that he had a subjective awareness of a substantial risk that that firearm was loaded with live ammunition. So give them everything else they say. Give them the disputed facts. They don't dispute that. It's clear on the face, pages 14 and 15 of their op. They do not dispute that.
What about the disputed facts? You talked about that they've raised additional facts. What about all the case law that says if you have disputed facts, it's for the fact finder? It is not for the court.
Your Honor, that's true only where the disputed facts, if resolved by the fact finder in favor of the state, could satisfy the elements of the offense. Our submission today is that assume the fact finder resolves every disputed fact in the state's favor. They do not contend he was subjectively aware that the gun in his hand could kill somebody, because they don't contend that he was subjectively aware that there was any substantial risk that it had live ammunition in it. So give them everything else they say. Give them they pulled the trigger. Give them he didn't attend the safety check. Give them all that for the purpose of this motion. Assume the jury resolves all of that in their favor. They still can't meet the elements of the offense. And that is the essence of a full and font. I would call it a Pacheco motion, because Pacheco really refined the standard, but that's the essence of the motion presented to the court right now.
All right. Well, let me read from Henley, because you read a certain portion of Henley, but there's more to Henley. And it says, criminal negligence required for involuntary manslaughter for a jury instruction includes the concept of recklessness, in which a defendant consciously disregards a substantial and unjustifiable risk that harm will result from his conduct. The Uniform Jury Instruction on Criminal Negligence incorporates this definition, defining criminal negligence as existing when a person acts with willful disregard of the rights or safety of others and in a manner which endangers any person or property. UGI 14133. Likewise, the instruction on involuntary manslaughter states that the defendant should have known of the danger involved by his or her actions. 14231. To be convicted of involuntary manslaughter, a defendant must have been aware of the risk caused by his or her conduct and continued to act. So I'm curious as to how you're narrowing that, because they're broadening that. And they're saying, look at all this other evidence that shows that he should have known. Number one, he had a bad armor that he's responsible for hiring. He should have known that she was a bad armor. Number two, he was aware that Halls periodically checked the gun, which implies that he also knew that he didn't check the gun from time to time. I'm trying to remember what else. The SAG guidelines that they don't completely rely on, and I think you said that they rely. If you said completely, they rely on them in part, and they're saying that as an actor, he, despite all that other information, that as an actor, he is not supposed to be pointing a gun at someone, and there's no need to use the gun, and that he pulled the trigger when he was pointing a gun that he didn't need to point to. So I'm curious as to how you have limited it to he has no knowledge because he got to rely on his armorer, he got to rely on David Halls, and you're ignoring all this other information that circumstantially, which is allowed, would indicate these elements. And that seems to be the core of what the jury is going to decide. And I'm not clear on how you're reconciling these kind of cases. A defendant's not, in fact, Murrieta, which you rely on very heavily, it says, State versus Murrieta. Defendant's argument both below and on appeal amounts to a disagreement as to how the fact finder should interpret the facts alleged. Such interpretations benefit from the opportunity to observe the testimony of witnesses, judge their credibility, weigh the evidence, and hear the parties' arguments after the close of evidence as a jury would have. Such contested facts, questions of fact in criminal cases rest within the exclusive province of the jurors. And then also in Uriad in paragraph, that was 17 in paragraph 18. Furthermore, defendant's knowledge of intent generally presents a question of fact for the jury to decide. So to me, and you did acknowledge that they have additional facts. And under the case law that I'm reading, additional facts can equal disputed facts, and if you have disputed facts, you don't get full and final. And these additional facts are disputed facts, regardless of whether the state says, well, these other ones we dispute now. I'm just concentrating on the additional ones. And to me, it seems that this is at the core of whether the jury believes your facts about the armor and David Hall's and that he had every reason to be able to rely on them, and the state's alleged facts that he was a producer, he knew about, he should have known about the armor, all these things. I'm not getting into whether it's true or false. I'm just wondering how you're reconciling these things.
Let me take a stab at that, Your Honor, and let me give you the short answer and then the slightly longer answer from both case law and the record. The short answer is add up all the facts that they say are disputed. Assume they win those. It still doesn't meet the legal elements of the offense. So you could imagine even easier cases than this, where something ridiculous. You know, there's a murder charge, but the person's not dead. And no matter what else is disputed, they're obviously not going to be able to prove a murder charge if the person's not dead. It doesn't matter if there's disputed facts. In this case, and let me pick up on Henley, Your Honor quoted the carryover paragraph from pages 107 to 108 in the Pacific Reporter. The very next sentence, the first full paragraph on page 108, gives the standard that's at the heart of our motion. It says, our case law has long interpreted the requirement of subjective knowledge into the the requirement of subjective knowledge into the showing of criminal negligence required by our involuntary manslaughter statute. Later in the same paragraph, it says criminal negligence in the context of involuntary manslaughter requires subjective knowledge by the defendant of the danger or risk. So the parts that Your Honor quoted are the model instruction. You know, we don't take issue with any of that. They may also have to prove objective knowledge, which is the should have known standard. But the subjective component, whether it's an independent component or part of what willful disregard and conscious disregard means in this context, it's clearly a requirement of the statute. I don't hear the state to disagree with this point. I mean, they can read the case just as well as anybody, and I don't hear them to disagree that subjective knowledge is a requirement under the statute. Now, Your Honor asked about these different factual allegations, whether the Hall's check was insufficient and so forth. Our submission is that even if all those were true, just as a logical matter, if he is not subjectively aware of a substantial risk that there's live ammunition in that gun, and they don't allege he is, he cannot satisfy that element of the offense because the only way that gun can kill somebody is if there's live ammunition in it. They can allege whatever else they want about he violated the STAG guidelines or he did this and that. But if they can't allege that he has plausibly, that there was he was subjectively aware of a substantial risk that the firearm contained live ammunition, they simply cannot meet the elements of the offense. I know Your Honor asked about Moreta. That case in the quote Your Honor presented says generally intent is a question for the jury. And we have no dispute with that. I mean, in most cases, recklessness, knowledge, intent, that's going to go to the jury, unquestionably. But where this state cannot allege, does not even purport to be able to prove an essential link, namely that the defendant understood that his actions had a substantial risk of hurting somebody else, it should not go to the jury. The Rule 601, 5601D standard is there because the judge is a critical gateway on allowing defendants to be prosecuted for things that are not crimes. What they have alleged here is not a crime. You cannot be guilty of involuntary manslaughter if you had no awareness of a substantial risk that what you were doing could harm people. And in the case of a gun, in this very unusual case of a prop on a movie set, where everyone, according to the state, believed it was empty, you cannot satisfy the mens rea for involuntary manslaughter.
Thank you. State's response.
Your Honor, as a preliminary matter, I want to ask the court, I know that the defendant filed a request for supplemental briefing kind of along with a supplemental brief yesterday, and we provided our response to that at around midnight. Is the court permitting the additional briefing? I hear Mr. Bash arguing the law and the facts that are in the additional briefing. So I just want to know what I'm responsible for.
No, I did not see that, and it's late. So,
okay.
Your Honor, can I just respond? I mean, other than the brief mention of the producer theory, I don't think anything I argued had anything to do with the supplemental briefing.
So he's right, but that's important because he said the state's new theory of him being a producer. Judge, you even know about it, so it's not new because I believe it came out during the Gutierrez trial, and as we indicated in our response,
here's what we're doing. Here's what we're doing today. What I received and what I set for hearing. So a supplemental briefing that arrived yesterday is not on the table in my decision.
Understood. Thank you. I'll go ahead and proceed with my response. The circumstantial evidence that the state intends to present that goes squarely to this issue is Mr. Baldwin knew he had a real gun in his hand. Mr. Baldwin specifically asked for the biggest gun that was available. Mr. Baldwin knew and understood that dummy rounds look identical to live ammunition. That's the foundation. So before Mr. Baldwin has ever even encountered training by Ms. Gutierrez, that's where we are. He then arrives to his training with Ms. Gutierrez and doesn't pay attention. Not only did Ms. Gutierrez indicate that he didn't pay attention, Ms. Zachary actually took a video of him not paying attention. And it's one of the exhibits that will be used in the destruction of evidence motion later today. So he decided not to pay attention during his training. Then, and look, anybody who looks at Ms. Gutierrez understands that Ms. Gutierrez hasn't been alive long enough to legally own firearms. So there has to be some question about, is this person really qualified to have this job? Any reasonable human being would have that concern, and many of the crew members actually mentioned that to the producers. How can this lady be our armorer? She's like in her early 20s. So Mr. Baldwin certainly understood that. He had a bad armorer. She wasn't doing proper safety checks. His experience in the film industry is absolutely circumstantial evidence that he knew that when she was doing these safety checks that she wasn't following the rules. Absolutely, the court is right. He also understood that Mr. Halls was not checking the gun with Ms. Gutierrez every single time. We know that he knew that because that's what he said to law enforcement on October 21st. So we get to this point. Now let's take into consideration that there are two other actors on set that Mr. Baldwin can see dry firing their guns into the ground 10 times after the gun is handed to them by Ms. Gutierrez to ensure that every single round is inert. Are those actors on my witness list? No. Do I have plenty of other witnesses who are going to come in and say, we saw those people dry fire their guns into the ground every time she handed it to them? Absolutely. Plenty of witnesses are going to testify to that, and Ms. Gutierrez herself should be able to testify to that based upon the court's ruling, because that certainly wouldn't be anything that she could assert her fifth to. So that's where we find ourselves at this point in time. Now, What Mr. Bash is telling the court, which is absolutely false, what he's telling the court is, unless this gun has a live round in it, it is completely harmless. And he didn't realize that there was a live round in it. Patently false. Mr. Baldwin himself, as I recall, had a conversation with law enforcement, and I may be wrong. I've read a lot of transcripts. He indicated an awareness that if he is handed a gun that has a blank round in it, but also has a barrel obstruction, that is fatal. That can kill someone and has historically killed people. I believe that that is the circumstance of the death of Brandon Lee that almost everybody who works in the film industry is familiar with. So Mr. Baldwin didn't necessarily have to know there's live ammunition in this gun. He had to understand that the gun is real. Real guns are dangerous. Dummies look exactly like live ammo. Even if there's not a live round on set and she put a blank in instead of a dummy and the gun had a barrel obstruction, Helena Hutchins is dead. She's dead. And she's dead because he didn't participate in the safety check. And listen, we agree, and we have always agreed that under the SAG guidelines, which do not dictate New Mexico law, the SAG guidelines indicate that that is optional. He chose not to participate, and I'm sure that's a decision that he's grown to regret. So he chose not to participate in that safety check. Then he decided to point a gun at a human being, cock it when he wasn't told to cock it. We have plenty of video of him cocking guns when he wasn't supposed to, when he hadn't been told to, when the scene didn't call for it. And then, of course, he pulled the trigger, killed a woman, and seriously injured someone else. So that's the landscape, and the court is absolutely 100% correct. The defendant has spent pages and pages and pages and pages arguing, we don't agree. We don't agree to the facts. There are really no stipulated facts. The state isn't stipulating that in order for that gun to have killed someone, it had to have live ammunition in it. Everybody knows that's not true. Now, let me clear up a couple of other issues. The reason that these safety rules exist, the entire reason that the SAG Safety Bulletin number 1 exists, is because of the risk that live ammunition could find its way on set. If there was absolutely no chance that live ammunition could ever find its way onto a movie set, why have these rules at all? You've got two actors standing right next to Mr. Baldwin who certainly understand that there's a significant risk of live ammunition, or they wouldn't be firing their guns into the ground right in front of him. Now, our expert, Brian Carpenter, will testify and testified before the grand jury, and I think he even testified during the Gutierrez trial, that as an armor, he himself has found live ammunition on a movie set. So what Mr. Bash alleges with regard to the distinction between involuntary manslaughter and second-degree murder really, I don't think, gets him where he needs to be. If I am an actor and I have reason to believe that I understand that there is a substantial risk that there is live ammunition on a movie set, and I take that gun and I point it at a person and I cock it and I pull the trigger, that is second-degree murder all day long. We can argue about that all morning, but that's not going to change. You know, I think that where the parties disagree here is when Mr. Bash was talking about the link, you know, the link between the subjective knowledge and the offense, the link between the conduct, the subjective knowledge and the offense. We disagree on what the link is. Not only do we disagree on the vast majority of the facts, we disagree on that link. This motion by Mr. Baldwin absolutely cannot be granted by this court. There is a plethora of case law that says you can't do it. And what is happening here, which is what frequently happens in this case, is the defense attorneys are coming forward to the court and they're saying, they're making statements that are not at all based on the evidence or the future witness testimony. One of those statements that was given today, of course, is Mr. Bash's statement, this gun can only kill someone if it's got live ammunition in it. Absolutely false. And Mr. Baldwin knew that was false. So we need to simply rely on New Mexico law. We have an extraordinary amount of circumstantial evidence that goes directly to this point. Some of that evidence you may see this afternoon because it's relevant to another motion. The court, if the court in Cerna, which is the unpublished case that the defense, that the state cited, that the defense was certainly aware of. They were aware of Cerna, they were aware of Gomez. They didn't cite him because they were hoping, I guess, we wouldn't find him. So when you look at Cerna, there's a video. There is a video of a person driving and a pedestrian stepping out in front of them. And the only dispute between the parties is exactly what Mr. Bash is bringing to the court's attention today, which is, you know, with substantial risk, how can you get there when you look at this video and all this lady, she wasn't speeding. All she did was just kind of make this turn and hits this pedestrian. And for heaven's sakes, it was an accident. And in that circumstance, the court said, no, there are disputed facts. There are disputed facts here. And we are asking the court to follow well-established New Mexico law and deny the defendant's motion. Thank you.
Response, Mr. Bash.
Thank you, Your Honor. Much of what the government just said is incorrect, but as an umbrella point, much of what the government just said is waived. It appears nowhere in their opposition brief, the point about blanks, the point about what two other actors were doing on the set. You know, there's been a lot of sandbagging in this case. It's not proper for when we make an important dispositive motion, the state not to present those arguments in their written submission and then to debut them for the first time at argument. The arguments are wrong, and I'm happy to address them, and I will in a second. But a lot of the points you just heard are not found in the brief of the state, and that you can't raise something at an oral motion for the first time without previewing it. So let me take each of those points in turn. Ms. Morrissey went over a lot of their allegations, and some of them are just have obviously no bearing on the issue before the court, whether he selected the biggest gun, whether Ms. Gutierrez looked too young for the job. That has no bearing on whether he had a subjective knowledge of a substantial risk that the gun in his hand could kill somebody. They've given a lot of facts. Let's give them all those facts. Let's give them all the jump balls. Let's say that they're right about everything they say. That does not establish the element of the offense. And we've been over some of those in the opening presentation, that he had the gun in his hand, that he knew dummies look like live rounds. The fact remains that they told a jury to secure a conviction that everyone on that set did not believe there were live rounds in that gun, and that it was inconceivable that there could be live ammunition on that set. And everyone includes Mr. Baldwin. Now, they've raised two arguments. I guess they've realized that they have a big problem, because if they can't show that he had a subjective awareness that that firearm was dangerous in his hand, they can't prove their case. And so they've raised two totally new arguments, which were not in the opposition brief. Someone can correct me if I'm wrong. I'm doing it from memory, but I don't remember seeing these arguments in the opposition brief. First, they say that Mr. Baldwin saw two actors dry firing their guns, but they're not going to call those actors, but they saw it. I don't see that anywhere in the brief. Second, they say that it's not true that you need a live round. In certain circumstances, a blank could kill someone because there could be an obstruction in the barrel and it could go off. But no one contends, Your Honor, that he thought there was a substantial risk that gun contained blanks, because as everybody knows, and I'm sure the court is very familiar after sitting through the Gutierrez trial, they look completely different than dummy rounds. Dummy rounds are the ones that look like live rounds. Blanks look totally different. And I'm not aware the state has ever contended that Mr. Baldwin was aware of a substantial risk that Mr. Halls or Ms. Gutierrez loaded blanks into that gun, which looked totally different. It's not even remotely realistic that was a risk after two professionals loaded the gun, that they accidentally loaded it with blanks. So that is an argument that the state just made up at argument. They didn't even include it in their written briefs, and it's completely preposterous in light of the reality of what blanks look like. It's an argument to try to get past a dispositive motion that doesn't actually have any weight. I would just add that I think they would have a huge problem with the foreseeability element if their theory was that he foresaw that there could have been obstruction that could have injured somebody, but actually what happened was totally different, and so he's guilty. I don't think they could satisfy foreseeability, but at any rate, the argument's waived, and it's factually ludicrous given that these things look different. There's no way he could have had a subjective awareness that there was a risk they were putting blanks into that gun. Ms. Morrissey referred to the SAG guidelines, and they say we have these prophylactic rules under the SAG guidelines because, there's some chance of live ammunition. And so you can never say there's no chance. Again, let's assume she's right about all that. I don't want to get into whether she's right about the purpose of the SAG guidelines. The standard is not no chance. The standard is a substantial risk. You heard it again. They can't argue substantial risk. They can't argue subjective awareness of a substantial risk. They would have charged second-degree murder if they thought they could argue it. So they moved the goalpost. And they've moved the goalpost to, well, we can't say there's no chance. I mean, there's always some 0.0001% chance of anything happening. But that's way far away from the element of this offense, which is substantial risk. She doesn't argue that properly because she can't argue that. She changed the goalpost. I heard her say something about the second-degree murder. Well, you're just wrong about that. Mountains of case law say you're wrong. There was no case law cited. There was no logical reason given. Second-degree murder in this state requires a substantial probability. If the state could allege that Mr. Baldwin thought there was a substantial probability that there was live ammunition in the gun and it could satisfy all the other elements, that would be a different story. But what we're saying is they haven't even alleged a substantial risk. There's a big delta between strong possibility and substantial risk. And if they can't even allege that, then it's not involuntary manslaughter. It's an accident for which he's not criminally liable. I heard Ms. Morrissey say that there's a plethora of case law that says you can't do a full and fond motion in these circumstances. There's not. They don't cite it. They just keep saying there's a plethora of case law. Moreta stands for the exact opposite proposition. It says generally they're not going to be successful. We have no truck with that. Of course, generally, the prosecutors are going to be able to get intent to the jury. But this is an extraordinary case where they're charging somebody with an accident based on a movie prop when they told another jury that everyone thought it didn't have live bullets in it. This is an unusual case. And Moreta would have had one sentence of analysis if the rule was you can't succeed on a full and fond motion on a question of intent. It didn't. It went very carefully through the allegations, and there was an attached affidavit, and it went very carefully through all that and said, okay, the state has enough here to prove the case. So they're wrong about that. And finally, Ms. Morrissey says, well, I know why the defense didn't cite Serna because they're scared of it. I mean, it's an unpublished non-precedential decision that alternatively applies a test that the Court of Appeals rejected in two published decisions. Okay, so it's not controlling. It does alternatively apply the correct standard, which is what the undisputed of facts allow the state to prove. And I mean, it was just a case with completely different facts. She said it's exactly the same thing. It's not. One of the facts disputed in that case, which was a vehicular case, a reckless driving case, was whether the defendant had accelerated at an unreasonable rate right before she hit the pedestrian. That was an actual factual dispute that goes to recklessness, and that could be dispositive. In this case, the state does not claim that he had a subjective awareness of a substantial risk that the firearm contained live ammunition. It's not disputed. For everything that Ms. Morrissey just said, they were not disputing that. She was candid. She did not sit here and say they can dispute that. There's a reason she didn't. They know they can't prove that. They know it would be inconsistent with what they told a jury to get a conviction of somebody else. They can't prove that. If they can't prove that, they can't establish the elements of the offense. And with that, I'll sit down, Your Honor.
Court makes the following ruling. The court denies the full and font motion of the defense. The court finds that, first of all, there does exist disputed facts before the court that are not capable of dismissal as a matter of law. The disputed facts are appropriately before the jury. The involuntary manslaughter talks about the defendant should have known of the danger, and I think that's really at the core of what is argued, that Mr. Bash is saying there's no way he could have known, so there's no way he should have known. And Ms. Morrissey is saying here is some circumstantial evidence as to how or why Mr. Baldwin should have known. With respect to the inconsistent theories of prosecution, you didn't really bear that out. I don't think you've met your burden. I think that the 10th Circuit, U.S. versus Negro, is on point where it's got to go to the core, prevail on due process claim. It's got to go to the core, and that it's got to be which is so inherently contradictory. And I think that I think part of what the state's relying on is what Ms. Gutierrez didn't do. Okay, and the court will prepare that order as well. I will see you back here at 1 o'clock. Does that work for everyone?
Your Honor, before we recess, I just have a question. The defense mentioned that I'm going to be arguing the Trombetta motion. We have 3 witnesses. The defense indicated they have witnesses. May we ask who they plan to call for that? I don't know if their witnesses are.
Yes, Your Honor. As always, it somewhat depends in part on who the state calls. It may be that we don't have any witnesses if they're calling the same witnesses. So we notified Corporal Hancock, Mr. Ziegler, and Mr. Haig. But if that's the same set of witnesses that the state's calling, we, of course, will be efficient with the court's time and not recall people.
They are, Your Honor, same witnesses.
Okay, very
good. So then we will, yeah.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
Real quick, Mr. Spiro, are you referring to Michael Haig or Luke Haig?
Luke Haig.
Okay. All right. Thank you.
All right. Thank you.
Thank you.
We're in recess.